Good evening. My name is Lara Zarowsky, and I'm the policy staff attorney with the Innocence Project Northwest Clinic at the University of Washington School of Law. And you've already heard so much information. I'm actually going to be switching gears just a little bit because so much of what you're hearing is about the litigation of individual cases and procedures that happen in cases. And my view is a little bit more of a bird's eye view in the sense that I'm in the policy arena of things. So where you heard from Jackie and her students about the litigation of cases, their focus is really on the litigation of cases, individual claims of actual innocence, and investigating those and pursuing those, where my work is more deals with policy reforms that might be able to come from what we've learned from DNA exonerations and non-DNA exonerations that have happened across the country in the last 20 to 25 years. So as you can probably imagine, just from maybe from your interest in being here in the first place, there's been a lot of study that has come from the DNA, particularly the DNA exonerations that have happened in the last 22 years. There's been the best data has been collected for the DNA exonerations, and so that's often what you'll hear people talk about in terms of percentages and causes and that sort of thing. And what we know is that some of these institutional factors that contribute to wrongful conviction in many cases can be addressed through reform. That's not to say that we're ever going to have a perfect criminal justice system, but we've learned things from the exonerations that have happened, and in studying those cases and learning about the things that maybe no one had intuition about for the past couple hundred years of our criminal justice system about what is an error or what is misconduct, things that have been happening the same way for a couple of hundred years. We turn out, oh, well, maybe eyewitness identification is not as reliable as we thought. Maybe we need to reevaluate the weight that we give to some kinds of evidence that we've been using. So that's kind of what the policy work is about. And we are a member, you probably have heard reference to Innocence Project, and that can mean the New York Project, or it could be individual discrete projects. We're all part of the same, what's called the Innocence Network. So the member organizations, and I believe there are 66, something like that, and not only in the United States, but now worldwide. And we're all, the primary purpose of members of the Innocence Network is to litigate the cases. But the more these cases come forward and we realize that there are changes that could be made in policies and criminal justice policies, the more the individual member organizations have started to institute reforms in their local jurisdictions. So here's an idea of what those reforms are, or at least can be, and some of the suggestions that have happened. So we have a few. These are just, and this is a really broad overview, but the causes of wrongful conviction, as we know, this numbers that the percentages are of DNA cases. And as you've heard, that number is about 284. And the work that Professor Gross has done at the University of Michigan in studying DNA and non-DNA cases, we know that the total of those two, not including the mass exonerations, is somewhere closer to 850 since 1989. So we're talking about a much larger number than you might perceive just by looking at the DNA cases. But that's what those percentages are. So, of course, the leading cause, as you have, if you learn nothing else tonight, you'll know that, of wrongful convictions is mistaken eyewitness identification. And in terms of the policy reforms that might go along with that, there are really two different, we have to look at that in two different phases. There's the collection of eyewitness evidence in the first place, which is what Steve has been talking a lot about. And one of the ways that reform might happen in that area is through law enforcement directly, and the way that they actually conduct lineups, and doing that in a way that that is going to reduce the likelihood that a bad eyewitness ID comes from the procedures that they're implementing. The other side of that is that there may be reforms in the trial practice. To the extent that law enforcement has not changed those procedures, we end up with identifications in individual cases, and there should be a way to be able to address, for a jury to understand the reliability of that testimony and that sort of thing. So some of it may, and that could happen through presenting an expert coming into court, speaking to the jury about the fallibility of eyewitness ID, or absent that, maybe a jury instruction. So these are just options that have been pursued in various places. As you've also heard, false and coerced confessions. My number is slightly lower than the one that Jackie cited but when you include guilty pleas for the DNA exonerations, it is closer to 25%. And one of the reforms that may be adopted to try to prevent a situation where someone will falsely confess, or at least giving more evidence about the circumstances surrounding someone's confession, would be to record the entirety of a custodial interrogation and not just the confession itself. Another cause, and you'll see that these numbers also add up to a lot more than 100%, and that's because most often, or very often in these cases of wrongful conviction, there's more than one factor that contributed to the wrongful conviction. But in over 50%, invalidated or improper forensics, and this could be either a bad technique that maybe a DNA testing technique that would formerly maybe included somebody is now can be more refined and will exclude someone, or it could be just bad testimony. Something that we believed in the scientific community at one point that has since been established that it's not good science. Those kinds of situations have contributed there. So some of the reforms that might happen is crime lab oversight. This is luckily something that we don't have to worry about so much in Washington because we have such trust in the Washington State Crime Lab that does our DNA testing. But it has been a big issue in some other states that have needed to do that. And I think something that can't be overstated is just having an understanding for the people who are litigating these cases, meaning the judges, the defense attorneys, and the prosecutors, about educating themselves about the science itself, whether that be eyewitness identification or the understanding of DNA and how it can be used. These are really important factors. And it certainly is true that the science can be there and the law won't have a full appreciation or incorporation of that science. There's not necessarily this, and unfortunately there's not at all an automatic relationship between the most recent study being done and that being fully understood and incorporated into the courts and into the system. So it's a matter of education. And finally, incentivized informant testimony, which was an issue in James Anderson's case. And it's actually, this is not something we see here, but it's a huge factor in death penalty cases. If you look at the data on death penalty cases, that the leading cause of, one of the leading factors leading to a wrongful conviction in a death penalty case is more than almost half of them are involved in incentivized informant testimony. So although it's not, you don't see that represented here in the DNA exoneration cases, it's interesting to see the comparison of those numbers. So this is just to give you a sense of the kind of reforms that have come out or are being worked on based on the information that we now know from the wrongful convictions that have happened in the country. So the question now is what's happening in Washington in any of these, and frankly a lot of this work hasn't been done yet, and that's a lot of what my job is to get some of these discussions going at least and try to get as much good work done in the reform arena as possible based on what we know from the exonerations that have happened nationwide. So this year, in addition to Jackie's clinic, where she has about 10 to 12 students that they litigate, they work on the cases themselves, the discrete cases of wrongful conviction or the claims. This year we've started a new program, and we've partnered with the Children and Youth Advocacy Clinic, which is another clinic at the University of Washington that is a legislative advocacy clinic. And we've partnered with them and 4 students are with me, and they're actually all here, but I'm not going to make them stand up. They're probably worried about that. But there are 4 students who are working on an issue. You can see the description here that they participate in the state legislative process on issues involving the identification, rectification, and prevention of wrongful convictions in the state. So it's entirely student-led in terms of choosing the issue that they wanted to deal with. And this year, they decided to continue the work that had been started the year before on working on getting a compensation statute in Washington State to assist those who have been wrongly convicted. And this will be the quickest brief on compensation, nationwide compensation laws that you'll ever see. But in general, there are 3 different ways that people who have been wrongly convicted are compensated in their individual states. One of which is a civil lawsuit based on official misconduct. They're often referred to as a 1983 claim. It's a section of the federal law that they can sue under. And that is based on official misconduct. So that's only the most extreme cases. They're difficult to prove. They have to establish that their constitutional rights were violated by generally the police or prosecutor in the case of suppressed evidence or fabricated evidence or that sort of thing. It can be very difficult to prove. Some of you may have heard of the Clyde Ray Spencer case out of Clark County. He was a former police officer and he was exonerated in, I believe, 2010. It may have been 2009. And his case involved, it was a molestation of his children was what he was convicted of. And his children recanted, and there's a lot of other interesting facts of that case. But he's actually filed a lawsuit at one of these lawsuits, and it's set for trial in April of 2013. So that shows you how quick of a method of being compensated that is. Another option that's available in some states, but it's not available in Washington State, is a private bill in the legislature, and that would be a law that's passed for the benefit of one individual person with the intent of compensating for them for the harm that they've suffered. And there's actually a provision in our state constitution that says no special legislation shall be passed, so it's not an option for exonerees in Washington State. And the third and final option is a compensation statute, a statute that the state will pass to allow someone to come into court and to claim that they were wrongly convicted and to be declared actually innocent and then generally receive some sort of standard payment depending on, it's usually a basic calculation based on the number of years that they spent in custody. So Washington is in the minority of states that don't have one of these compensation statutes. 27 states, Washington, D.C., and the federal government have all have passed these statutes. About 13 of them, I believe, just in the last 10 years or so. But the first ones were passed in 1912. So this is not something that has gone without notice. We've known that this is an issue, and that it's been accepted that these situations should be compensated for a very long time. So last year there were 3 bills introduced in the state legislature. It was not the first time. The first one, I believe the first bill was in 2005 or 2006, another one in 2007, and a couple of years of, I think again in 2010. The issue kind of comes up every once in a while, but since Larry and Alan and Ted were all exonerated in 2010, then it became apparent that in the 2011 legislative session it should be something that needed to be pursued. So 3 bills were dropped by 3 different legislators. House Bill 1435 by Representative Tina Orwell, and she's from Des Moines. It was a civil cause of action against the state, $50,000 a year plus services and tuition. Senator Jim Hargrove introduced one as well, and that bill was the one that actually had some movement and passed the Senate Policy Committee, but didn't make it through the Fiscal Committee. And it was also a civil cause of action, but provided much less. And just for a benchmark, the federal statute provides $50,000 a year for each year of wrongful conviction, and it's widely considered sort of the accepted standard of what a fair amount would be for wrongful conviction. And the third bill that was introduced was tried to take a whole different approach, and it was just sort of a creative brainstorming piece on the part of that legislator from what he let me know. And it was just meant to try to avoid a court procedure altogether, but had some issues with it. But all 3, because we have a biennial legislature, it means it's every 2 years. Any bill that's introduced in the first year of the biennium is technically alive and available to be scheduled. We don't know if any of these will be heard this year, as they were one of them was last session. But there's a new bill this year, House Bill 2221, that's also Representative Tina Orwell, who's been really a leader in this, in being interested in getting this passed for the last couple of years. And this is slightly different than the bills introduced last year in that it would name the county where the wrongful conviction occurred as opposed to being a lawsuit against the state. But other than that, it's largely the same benefits would be provided, $50,000 a year, eligibility for health care coverage for up to 10 years, and tuition for the exoneree and any of their qualifying children, which is something that's not done anywhere in the country, so that would be a great new thing to include. And that is actually, much to our surprise, scheduled the first week of session, which is this week, and it happens to be tomorrow morning at 10 a.m. in the Judiciary Committee on the Capitol campus, so anybody interested in taking a field trip, we'd love to have your support. And I think that concludes, that's about it for now. Do you have any questions? All right, thank you.